Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi weekly community conference call, which we try to do every other Thursday. We've been so far consistently doing it for a couple of decades. I'm going to start first with frequently asked questions, take up any follow up questions. There's, I think, 3 of them today, and then go on to the routine questions that people have posted. But before that, there was somebody from the community who had said there was some sickness in the family, some issues with one of their friends, some cancer treatment going on, and status issues. If you are here, please press *5. Press *5 on your phone if you are here. Somebody who had sent an email about sickness in the family. Okay. All right. So I see that you are here. I'm going to unmute you so you can tell me what's going on, and I try to give you the best guidance I can. This was not a posted question. This was just something that had come up urgently. Go ahead. I can hear you. Go
Yes,
ahead, please.
sir.
Yes, sir.
Yes, sir. So I'm Satish. This is for one of my friends. He is there in the hospital along with a kid.
Right.
So the child was he's like 4th grade now. Has been detected with this leukemia cancer, and they are about to do a bone marrow transplant.
Sure.
So his H-1B was expired in the month of Jan or March. Yeah, March. And then meanwhile we filed an amendment cum extension, and his 240-day period is going to be over by September 8th.
Okay, hang on one second. Hang on one second. When you file for an amendment, the 240 days don't apply. Okay? You can continue working yes. as long as the case is pending.
Okay. Okay. Yeah. Sure, sir. Thank you. And so another question was, we got a letter from the doctor stating that the kid has to stay here for a prolonged duration. Maybe it's like 18 to 20 months based on the availability of the matching bone marrow. So my question was, is there any possibility that this H1 can be approved based on these medical conditions? Any documents that we can provide?
No. There is no provision. There's no provision in the law for getting an H1B approval based upon a family health emergency.
Okay, so any other ways wherein we can, even if it gets denied?
Only thing that could work and may work, because this is such a sad story, you can try getting together some community members and go see your congressman to assess whether they can propose a private bill for the family. What is a private bill? A private bill is almost like passing a special law to give somebody a green card. So you can actually Google that. You can Google private bill for immigration, and you see that there is a history of it. Now, under Trump's America, who knows what's going to happen, but it's worth trying that, and that's the only thing that makes sense. Okay.
So another question that we have also filed is he got his perm approved, and the one for baby got an RFC for his educational background. So what has happened is he did a lateral entry in India. So after completing the diploma, second year he joined engineering, and it was through a distance education.
I know how that works. So you first get a diploma, that's 3 years, and then you go directly to second year engineering. Yeah, that's a common pattern. I don't think that's going to be a problem.
No, but so he has gotten a distance education, distance learning system, and Supreme Court has given a verdict in 2016 that this university is no more valid.
Yeah, I remember this
So,
case. I remember this case.
Mhm. So is there any way we can get this 140 approved by providing any documentations, or is it like we'll have to file all through again?
Well, I think the university's UGC recognition was revoked, and I'm not sure what else you can do. I don't remember the details. I think we've dealt with one of these cases that was approved, but I'm not sure why it was approved. I think it may have been prior to the time. I think the Supreme Court gave a date from which the certification or accreditation was no longer valid. But somehow I think we did manage to win one case. I don't remember the details. This was a long time ago.
Okay.
So have your lawyers look
Okay,
into
so
it.
there is a possibility maybe.
You never know. I mean, I don't know.
No, sir.
I don't know if I can do anything, but have their lawyers look into it. See if there's an argument to be made based upon the time frame.
Okay.
Okay.
Okay, sir. Okay, sir.
Good
Sure,
luck.
sir. Thank you. Thank you
You're
for
welcome.
all the
Bye-bye.
details.
Okay, folks, let's get on to our frequently asked questions. The first one is from Jai Vijay, talking about changing employers after receiving employment-based green card. So he's got his green card for a couple of months. I had the intention to work for the employer who sponsored me during applying for the green card during the interview also. However, after working for a couple of months, he wants to change the employer closer to his home. He has some health issues, such as heart condition, etc. I'm planning to search for a job near my home. So the questions are, will I face any issues now or during naturalization because I changed my job after 2 months of getting the green card? I'm planning to save my pay slips, etc. and my heart health records. Is there a minimum duration USCIS expects a green card holder to work? And the answer is there is no magic number. People spin out numbers like 6 months, etc. But none of them are really reliable. The real criterion is what your intention was when you got your green card. You have unique health issues, and one of the questions that I would want to ask is, did those issues exist even when you filed for the green card, or they developed during the pendency of the green card? That would be one thing. Second thing I would want to know is, did you really try, for example, instead of finding a job closer to your home, why can't you move closer to the job? Right? That's a normal and natural question. I really can't get into all the details because there are so many variations possible. But if you can show your good faith efforts to continue working there, the fact that you are leaving them in a relatively short time frame should be at least debatable with the government. Would you win such a case? I think you would, but that's just my professional judgment. That's never a guarantee. *5 if you have a follow-up question. *5. Press *5 on your phone. Okay. Next frequently asked question was from Pradeep, Virginia, who's asking about working on EAD after H-1B denial. So he's got a 485 based EAD. What if my H-1 extension gets denied? Can I continue working on the EAD? And the answer is yes, you can. Should we delay responding to RFE until the new EAD has been received? Well, under the new rules, your current EAD expires in October 2019, after which you have an additional 180 days grace period to continue working. So I don't think that should be too much of concern for you. Is it necessary to pursue H-1B and spouse's H-4 expedition given 485 is pending? I don't think you can expedite on that basis just because 485 is pending. What are my options if I don't hear anything from this service request? This is about the green card. I think the congressman or woman are usually the better choice, but don't do both. Don't contact the ombudsman and the congressman. Choose one. Okay. *5 if you have a question that follows on this fact pattern. Okay. So we have one coming from Kansas. Okay. Kansas, go ahead. I can hear you.
Hi. Sorry, it was a typo. It's not an expedition, but I was wondering if H1B or H4 needs to be extended, given that 45 is pending. Is it necessary?
I always do it because there are so many ways the 485 can go wrong. We have a client who just, well, they haven't hired us, but we've sent the paperwork to them to be hired for denial of an I-485 because they left their employer within 180 days after filing the 485. Now, that's really not a ground for denial. Leaving the employer doesn't mean that the 180 days will stop running. Nevertheless, government has denied his I-485 and we are filing a motion to reopen. So that gives you an example of how 485s can go south. And if this gentleman didn't have an H-1B, it would be difficult to fight his case. So the short answer, yes, keep the H-1B alive. Okay?
Thank you.
You're welcome.
Yeah.
All right. I think I have one more frequently asked question. Yes. So sometimes people have name discrepancies. Like for Ram, all his life he was Ram space Kumar, and then he started putting himself down as Ram no space Kumar. The way I would handle this is I would either do a formal name change before I go on with all my paperwork, or I will do a formal name change after I get my green card. What does a formal name change mean? You contact your local general district court, ask them to send you information about doing a name change. They will, typically they have a package that requires publication, etc. So you can do a formal name change through the courts. Once you do that, you can then use that and change your social security number, driver's license, your green card, anything that is connected to your identification can be changed from one name to the other. That's what normally I would recommend. Do it either before starting the green card process or after its termination. *5 if you have a follow-up question. Okay. I don't think we have any other frequently asked questions. All right. So let's go on to the non-frequently asked questions. I'm sorry, Kala, I don't know anything about asylum cases. So really can't comment about whether you can get your passport renewed or not. You'll have to talk with somebody who does asylum cases. Jersey Garden has a series of very fact-specific questions. I'm not sure I have the time to answer them all in this call, but I'll do the best I can. Wife is on F1 OPT till 2020. H1B was picked up for 2019, has an RFE. RFE response is due September 1st. Not sure when will the H1 get approved. My 60-day grace period is August 30th. Can I file F2? Not sure if F2 gets denied before H1 is approved for my wife. If wife's H1 post gets RFE approved, we'll file change of status from F2 to H4. In between above scenarios, what happens to my current I-797? which has an I-94 end date of October 2020. I-94 by itself doesn't give you status. You actually have to work. Do companies and their attorneys offer job, and are they interested to file for H-1 when you have a pending F-2 or H-4? I don't know the answer to that question. I don't think I can speak for the entire world of employers or lawyers. If somebody needs you desperately enough, they'll be willing to work with you. If H-1 gets approved, do I need to leave country for stamping? Well, that depends. You see, if your I-94 has expired and you are not maintaining old status, when the time comes for your H-1 to be decided, government can ask you to go outside USA because they cannot adjudicate status when the old status is in suspense. So that's the worst case scenario. And then you have, going back to the question of the F2, which is a little tricky. Should you be filing for a bridge case? Well, I don't know if F2 is the best option for you because your wife is also pending H1. So maybe you can file for a business or a tourist visa, and that might help. *5 if you have a follow-up question. And whether or not you need to leave the country, the answer is the same as number 4. Was it number 4? No, number 5, which was, do I have to leave USA? And the answer is, if you are maintaining status, no. If you are not maintaining status, old status has expired, new one is not yet approved, then you probably will have to leave USA. *5 if you have a follow-up question. Okay. Krish 176 has a priority date 2009, has a combo card. Spouse got an EAD only for 1 year. Okay, now the question is, can we file for EAD and advance parole at the same time, asking for an extension when only EAD needs to be extended? You should contact customer service. They might be able to issue you a 1-year EAD. I don't know the answer to that question. It's too fine-tuned or too much of a tertiary issue for me to know off the top of my head. I would want you to call the USCIS customer service. I don't think a lawyer is necessary, but you may want to at least do a consultation. But do that after you had a talk with the USCIS. *5 if you have a follow-up question. *5. Okay, let's go on to the next question. NK Gokana has an approved I-140 for current employer. This is my second approved I-140. I had one with the previous employer, which is revoked now. Priority date is 2013. New employer will start green card after 4 to 6 months. Is there any issue in accepting the new offer? And I don't see any issue. I think that should be fine. If the new current bill is approved, there are so many bills going on all the time. I really can't comment on that. Every session of Congress, we get 10 new bills on immigration. So I can't really comment about that. I don't think there's going to be any major immigration changes so long as Trump is in the White House. Will there be any issues in accepting the new offer or the current bill? So I don't have anything else to add. *5 if you have a follow-up question. *5. Okay. Jordan has a question about public charge, and if I remember correctly, these regulations don't talk about naturalization. There might be other issues related to naturalization, but I think public charge issue only relates to admission. It does not relate to naturalization. But I haven't really reviewed the new regulations. I'm waiting until they've had a little bit of time to settle down. We'll take a look at them. Most of our clients are not concerned with those regulations, but I can't really give you a definitive answer today. Next question is Sismandu, arrested for simple DUI in California. Convicted, paid fines, got 3 years probation, which ended on June 2017. When does good moral character start for naturalization? Is it the date of conviction? You know what? I don't remember. I remember reading this issue, but I can't tell you off the top of my head. Shaina Saeed says, filing for I-130 for an unmarried child over 21. Is the evidence of termination of marriage for unmarried child over 21 required when we file? Yes. You should attach that evidence because this is part of the initial evidence as far as I know. *5 if you have a follow-up question. Okay. 2010 PD says my perm got approved with 2010 PD and my employer applied I-140 within 180 days. I-140 was rejected without receipt, saying the fees changed and so they gave the wrong fees. By the time they applied again, the 180-day period was over. So now the question is there any way to save that I-140? I have to look at the policy the Department of Labor announced, because there's no doubt that if your I-140 had been accepted for processing and then denied, you could always file another I-140 using the perm that was more than 180 days old. That's allowed. Is it also allowed if the filing fails? Is there anything you can argue? I do not know the answer to those questions. I have to review the policy. Definitely, it should be looked at. Maybe there is something you can hang your hat on. Okay. The problem is you cannot retain the priority date of the case, an I-140 that is not approved. However, if you're allowed to file an I-140 past your 180 days of perm approval, then you will certainly be able to carry it forward once the I-140 is approved. Okay. *5 if you have a follow-up question. *5. Question number 13. Amar Singh. 2 separate employers filed. Well, first of all, when 2 separate employers filed for your H-1B and the employers are not related to each other, the jobs are different, that's perfectly allowed. There's no problem. Normally, if an employee is not working for you, you have to withdraw their or revoke their H-1B. I don't think this is a multiple filing issue, Amar. Multiple filing issue would occur if the same company or related companies filed your H-1B. So, are you going to get a notice of intent to revoke or deny or an RFE? Well, it's not really an RFE, I guess. It's the notice of intent to revoke. Multiple H-1B filings should not be of concern here. So I'm not really that concerned about it, as long as the 2 companies are not related. *5 if you have a follow-up question. Okay. Rani Kalra is a gay lady who was living with her partner and there's some history of abuse, etc. Ma'am, this is not really my field. I would suggest you talk with 2 kinds of lawyers. You should definitely talk to a domestic relations lawyer because you were married. So you need to figure out what your rights are. And then also talk with an immigration lawyer who can help you assess your visa possibilities if that is even an issue. Because I'm not sure you have a green card. My spouse visa papers are filed, but interview hasn't happened yet. So if the marriage was entered into in good faith and later on dissolves, that should not affect your green card. Again, you need an immigration lawyer. And in this case, I would prefer for you somebody local, because if there is an interview, it would be nice to have a lawyer there. *5 if you have a follow-up question, Rani. *5. Okay. So Memocal has a husband who's unlawfully present in the United States for 2 years. Does my green card help him? The answer is no, not until you get your naturalization. *5 if you have a follow-up question. Okay. Next question. Satya Amara. A wife applied for H4 EAD. She visited India, returned back. So if she was on H4 when she left, leaving is okay. Government did say that if you travel while the EAD is pending, you might end up expanding the delay, but that doesn't mean that it's going to be a problem by itself. So there could be some delay, although I have never really observed that. *5 if you have a follow-up question. And you shouldn't have to apply again. I don't see why that should be even a problem. Okay, let's see. This one is from Oklahoma. Yes, go ahead, please, Oklahoma. Hello.
Hello.
Yeah, go ahead, please.
Yeah. Yeah, this is me, the question about you answered right now. So the only concern we have is we attend for stamping. So will that impact my H4 EAD?
I don't see how that would impact your H4 EAD. I don't think so. Okay.
So I don't have to apply anything new, just the same application.
I don't believe so. But again, just to be overly cautious, go ahead and contact the USCIS customer service. Okay?
Okay.
Good luck,
Okay.
ma'am.
And one more question.
Yeah.
So when we got visa stamped, I got for 3 years, and also H4 I got the extension 3 years. But when I entered into the United States, in the immigration department, they gave me only 1 year because my passport is going to expire. So do I have now 3 years or 1 year? I don't
You have 1 year.
understand now.
You have 1 year, and you have to extend that in one of the two ways. Either you apply for an extension just like you would file a normal H1, or do you currently have a visa stamp on your passport that's still unexpired? Do you have an H1?
Recently, yeah, yes.
Okay. And how long is that good for?
It has 3 years.
Okay. So what you can do is, you can take a day trip to a neighboring country like Canada or Mexico, and coming back, show them the approval notice and the visa. They should be able to give you an I-94 covering all the way to the end of the 3 years already approved. And by the way, there are posts, Customs and Border Protection posts within USA. I remember twice we have sent clients to, I think it was Freedom Bridge in Texas, Austin, Texas, I think. They have a post there. They charge, I don't know, like $15, and they can extend your I-94 within USA. So look into that. Have your lawyers look into that. Either go outside or get your status extended within USA through the Customs and Border Protection. Okay.
Okay. So do my H4 EAD, if I get approved, will I get for 1 year or 3 years in this case?
I'm sorry, I thought you were on. Hang on. Oh, I think I have the wrong question. Give me 1 second. Oh, okay. That I don't know. I thought you were on H1 for a second there.
No. Actually, we got H4 extension here. We
Right.
traveled to.
Yeah, I got that.
For H4 EAD.
I have your question now. I was on another question. So I personally don't think they're going to give you 3 years because, well, although when you filed when you had 3 years. You know what I would do, just the practical solution to this problem? Just go get your I-94 extended all the way to 3 years. Then come back and contact the USCIS and ask them if you need to do anything to get 3-year EAD. Okay?
Okay. So now, because of visa stamping, so in this case, now I need to contact USCIS, you mean?
Not USCIS, Customs and Border Protection, to extend your I-94.
So I'm talking about H4 EAD approval.
Once you get the I-94 extended, then you come back and ask USCIS what you need to do, if you need to do anything at all. Because when you applied, you had 3 years. Now again you have 3 years. In between you did not have 3 years. Do you need to do anything? That's the question.
So my passport, because they gave 1 year, because my passport is going to expire on May 2020. Now I cannot. Can I able to?
You need to get without the passport extension, they'll bother you again. So really, the sequence of events has to be passport extension, I-94, then contact USCIS.
Because I already applied 3 months ago, and it's almost nearby my EAD. So,
ma'am, you're going around in circles, asking me the same question over and over again. I just told you. I understand you applied. I just told you. You gotta extend your passport. You gotta extend your I-94, and then you gotta contact USCIS. End of story. Okay.
Okay.
Good luck.
Thank you.
You're welcome. Last question for today, folks. This is, I got my employment-based green card under EB2. This was in 2013. Want to apply for citizenship. Before getting green card filed by employer A, I moved to employer B in December 2011 and then never worked for A even after getting green card. Reason, they did not have any jobs because of bad labor market. After getting green card, I did use benefit once, child bonding. I don't know exactly what that particular public benefit is. Can't really comment about that. But the part about not joining the sponsoring employer can be tricky. I think you need to contact a local lawyer where you are. I prefer you establish a relationship with a local lawyer because they can go with you to the naturalization interview. In tricky cases, I would rather have you go with a lawyer. And this can get tricky. I personally am disinclined to file naturalization in any case where there's a gray area. This is a bad time to try to naturalize. *5 if you have a follow-up question. *5. Okay. So this one is from Simi Valley, California. Okay. California, go ahead, please.
Yeah, hello, Rajiv. First of all, thank you very much for the free conference that you're providing.
Absolutely.
So my question is, if I don't naturalize, then my 10 years of green card will be coming up in next 3-4 years. So
that's not a
that time also I will be facing the same issue.
You can keep extending. No. Extension of the green card is an administrative procedure. It does not require looking into your background.
Okay.
Naturalization requires a great deal of study of your background. Immigration renewal does not require any such thing.
So My 140 was approved in 2008 and I moved out of this employer in 2011. So wouldn't AC-21 automatically get applied even if I don't file for it?
Yes, it does. And that's not the issue. I thought the issue was you never joined the sponsoring employer.
That is correct. I never joined them because they were not having any job.
So even though AC-21 is a defensive, a good defense, in fact, the Yates Memorandum of, I believe it was May 2005, clearly said that even if you have a job offer from a future employer, even if you don't join them, you can still do an AC-21 portability. That memo actually, if I remember correctly, said that specifically. So, but that's not the issue. The issue is, do you want to get into an argument with the government? And that's why I want you to have a conversation with a local lawyer. If you're in California, go to somebody local who's smart and a good lawyer and can spend some time on your case and figure out whether filing for naturalization is a good idea. Okay?
I see.
Yeah.
So in worst case scenario, if I file for citizenship and it gets denied, so in that case, your green card is also revoked?
They can go after your green card. It's not automatically revoked, but they can go after your green card. Okay.
I see.
Yeah, I think you would still have a very good argument, but I have received I've done some consultations in cases where it just doesn't make sense for denials to occur. And I gave an example, I don't know if you were on the phone then, of somebody I did a consultation for who left their sponsoring employer. They were working with them for a year plus. They left the sponsoring employer before 180 days of 485 were done and joined another employer. Now, that's never supposed to be a problem. As long as 180 days pendency is reached, whether or not you are still employed with the sponsoring employer is irrelevant, but the government has denied his green card. So we might even actually end up taking this case to the Court of Appeals. I think for now we are just doing a motion to reopen, but I'm preparing the record as though we are going to go to the Court of Appeals. So the point is, this is a bad environment. I would not like to do any procedure that is unnecessarily risky. Okay?
Yeah, I totally get that, but it's a catch-22 because if Mr. Trump comes again, you never know what kind of laws he's going to pass next time.
Well, he wants to pass all kinds of laws, but it doesn't matter what he wants. As long as we have the House, he cannot pass any laws. The laws remain the same. He can try to tighten as much as he can, and he gets smacked down by courts all the time. So yeah, it doesn't mean, I personally am not concerned about him being able to tinker with the laws. As long as we have one of the houses, they can't change laws. Okay?
All right, thanks, Rajiv.
You're welcome. Good luck.
Thank you.
Guys, I have about 20 minutes before I have to go, so I'll try to answer any new questions people have. Press *5 if you have a question. *5. Any question? Okay. Let's see how many we have. We have three questions. And in the order in which you joined, let's take that. So the first one, okay, no, we have 4. All right, guys, that's all we'll be able to do. 4 questions, about 3-4 minutes each. But normally that's okay. So let's start with Oklahoma. Oklahoma, go ahead, please. Oklahoma, go ahead.
Yeah. So my H4 EAD I applied 3 months ago. So I'm waiting for that. I'm a school teacher in public schools. My principal badly needs me, that position she needs for students. I need to teach there.
Mm-hmm.
So is there anything I can do before my approval?
Yes. Go to any of your search engines and type USCIS expedite criteria. Type exactly this phrase, USCIS expedite criteria. One of the expedite criteria is that the employer needs you right away. And I think this is where you have a school session and children could get affected, it's worth a try. You might be able to expedite. Okay?
Okay.
Good luck.
Thank you.
You're welcome. Okay, let's go to the next one, which is New Hampshire. New Hampshire, go ahead, please.
Hey, Rajiv.
Hello, sir.
Hi, I have a question regarding automatic visa revalidation process.
Go ahead.
So the situation is, current status is H1B and H4. Visa stamp for H1 and H4 expired in 2015, and they were on the old passport.
All right.
Current status or the I-797s are valid till 2021.
Okay.
Okay. And the H1B strength is employee vendor client. H4 candidate is currently working for company A and has a pending H1B cap petition for a company B.
Too many facts, I'm not able to keep them straight. What is your question?
So basically, if we decide to use the automatic visa revalidation at the port of entry while traveling to Canada or Mexico, will there be a difference if the H4 candidate who is using the automatic visa revalidation also has a pending H1B cap petition for a company B?
It makes no difference for the AVR, but here is the problem. If you leave USA while your change of status is pending, the change of status is abandoned. So that's a dangerous thing to do. Check with your lawyers before you do that.
Okay.
Okay. Anything else?
Okay, I think that's
yeah. So just be careful with that. That's the problem. The problem is not the AVR. AVR is available if you have a change of status pending, but the change of status will be denied if you leave US.
Got it.
All right.
Okay.
Good luck.
Thanks a lot.
You're welcome. Okay. The second last question is from California. Okay. Yeah, California, go ahead, please. I can hear you.
Hi, Rajiv. I have a question on the Blvd. Can a person buy any of the stocks trading in New York Stock Exchange? Will there be any illegal stocks out there which I should be avoided? On an EAD, H4?
First of all, I think you can buy stock even if you are not on EAD. Okay? Because it's a passive investment. On EAD, you can buy as much stock as you want and you can day trade if you want. Now, are there any illegal stocks? There is no such thing as an illegal stock as far as I know. I'm not a SEC expert, but if something is listed, how can it be illegal? So buying stock is not illegal. Now, be careful about one
like
thing.
The cannabis stocks.
That is the
Canada,
problem. I was about to tell you that. Cannabis stock can be a problem because that could lead to exclusion or refusal of green card or H1B paperwork. Oh, now I understand what your question is. Yeah, don't go into cannabis. That's a very gray area of the law.
Okay, thanks.
Okay, good luck.
Thank you.
Last question is from Oklahoma. Oklahoma, please go ahead.
Hey Rajiv, I got my green card a couple of months back. So my question is, I had I-140 approved from employer A back in 2008. So the priority for that is 2008. And then I had one more I-140 which was approved in 2019 with employer B. And employer B applied for my I-485 petition with employer A's, I-140. And when I went for the interview, they approved me with the employer B's I-140, which is EB2. First one was EB3 and the second one was EB2. So the interviewer said he is going to approve the I-485 petition with employer B's, EB2 I-140.
Mhm.
So does it mean that my sponsoring employer is employer A or employer B?
Okay.
So I'm just
Okay.
kind of curious.
Sure. And I can see that why it would cause you some concern. I'll give you the law and then you tell me how it applies to you. Okay? First of all, number one rule, the law allows you to transfer priority date from EB3 to EB2. Okay? That's perfectly legal. If you have a priority date in EB3, it can be transferred to EB2. No problem. Okay? Green card is decided based upon the I-140 that you filed and asked the government to adjudicate. So if you think about these two facts together, you went in saying, I have a I-140 approved through employer B, but I have priority date coming from employer A. Please approve my case. Employer B is your sponsor, not employer A. Employer A is merely giving you a priority date. Okay?
Oh, okay.
You're
So
fine.
employer B is my sponsor, and basically I got something like C26 or something like, which is an upgrading the case from EB3 to EB2. So and the interviewer also said that it's EB2 approval. So employer B is my
It's
sponsor.
perfectly
Okay, got it.
fine. Double check with your lawyers. I'm pretty sure, I haven't seen the paperwork, but the fact that you're describing appears to me very very common, where somebody has a green card approved based upon an old priority date but a new petition. That's fine. Okay?
Okay. But when they applied for I-485, they applied it with just EB3 I-140, and then during that time my EB2 I-140 was approved, and then during the interview process they
Even that is
said
legal.
he's going to
Even
take the later.
even that is legal.
Okay.
Even that is legal.
Okay.
My only
Okay.
concern would be,
Okay.
if they applied for an EB3 based I-485, did you have a job offer from your EB3 employer?
Yes, initially I had the job offer.
So,
but
hang on. So the 485 was filed a long time ago, was it? Sir?
Sorry, I didn't get you.
The 485 was filed a long time ago?
485 was recently filed.
That doesn't make any sense. What you're describing to me doesn't make any sense. I might need for you to do either a consultation with your own lawyers or with us. What you're describing to me makes no sense. Something is wrong with this picture. The prior picture I had made sense. This one doesn't make sense. Okay? So how can they apply for an EB3?
Sure, I'll call.
Yeah. You can just send an email to frontdesk@immigration.com. One word, frontdesk@immigration.com. Just tell them Rajiv said make an appointment for a level 1 consultation. Okay, they'll take care of it for you.
Yeah.
Okay?
Yeah, sure.
All right, guys, I can't do any more questions. I know some people are raising their hands now. That time is past. Good luck. Good talking with all of you, and I'll see you again in 2 weeks. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.